Yes, Mr. Knox.
I'm going to make a correction in a moment to something I said before lunch, but before I do that, can I just say what my third preliminary point was? Because I'd given you two preliminary points and I've got rather diverted. But can I just mention...
I've got at least four.
Well,
never mind.
They tend to grow. But anyway, this is a separate point, but I will come back to a correction I want to make in a minute. The other point I do want to emphasise, and that is there was no appeal against the judge's ruling that the state was not obliged to pay for the appellant's lawyer of his choice under Section 5(2) of the Constitution. The judge having held he wasn't restricted in his right to choose one, and mere inability to pay does not of itself constitute a breach of your constitutional right under 5(2)(c)(3). That's at page 119, para 28. I submit it's important to bear in mind, and I'll elaborate on this point later, that this was essentially a dual claim that was made. The judge rejected that, and there's no appeal against that. So again, one starts from the premise that there is no constitutional right as such to have the state fund you for the lawyer of your choice. Your constitutional right as such is what is afforded by the Constitution and your statutory right to legal aid. My Lord, the point of correction is this. Before lunch, I said that the appellant was seeking judicial review of the order for a de novo hearing. That is correct. That was what he was seeking judicial review of. But the basis on which he was attacking that order was that it had been made unfairly. And he was not yet saying, I want the case against me dismissed, therefore. And you get that at page 676, paragraph 29. This again is in the judgment of Madam Justice Gobin.
What was the page again?
676, paragraph 29. Perhaps pick it up at paragraph 27, you can see the appellant's complaints. Essentially that the process had been dealt with in a secretive way. Paragraph 675, paragraph 27. And then paragraph 28, that argument was rejected. And there was sufficient disclosure, essentially. And then paragraph 29, the claim for judicial review, or what was pursued before me, was limited to claims of procedural unfairness. So the claimant has not suggested that the unavailability of the magistrate which rendered the proceedings abortive should automatically or necessarily result in his discharge or in a permanent stay of the proceedings. The law couldn't contemplate what would be perceived as an automatic frustration of justice in favour of accused persons. This is not to overlook the extreme hardship, oppression and prejudice that's bound to be suffered by the claimant and many others, similarly circumstanced as a result of the order for a de novo hearing, and so forth. So, my Lord, that was the basis. She continues, which consequences might more appropriately be considered if and when Mr. Charles pursues his claim for relief under the Constitution. That hasn't been addressed. So it looks as if at this point Mr. Charles was perhaps potentially lining up a future claim to say I should be released, but in this proceeding he was simply objecting to the order for a de novo hearing. Now, the point has been made to me, this is why I want to come back to it as well. Well, surely the judge said, Madam Justice Gobin said, well, it wasn't unreasonable for the claimant to challenge, or the appellant to challenge, the order for a second inquiry, de novo inquiry. Surely that's not unreasonable. And therefore, surely there's a sufficient chain of causation, let us say, between the maladministration by the state in elevating the Chief Justice Chief Magistrate to the High Court bench without it being ascertained one way or the other what the state of her list was. Now, in my submission, that's not the test when you're dealing with protection of the law. And this, I submit, is a fundamental point. The question in this case is, in the circumstances taken in the round, was the appellant denied the protection of the law? That's the question. And my answer to the point that was put to me by my Lord Briggs and Lord Burries is this. There plainly was another course open to the appellant in June 2019. That is, go for an expedited second preliminary inquiry, as evidently happened in the case of other accused people. The law actually afforded that remedy. He, reasonably or not, decided not to take it. He goes for a different remedy. No doubt because eventually he wants to circumvent the need, perfectly understandably, for another preliminary inquiry. But that isn't the question. The question is, did the state, as at June 2017, provide for an adequate system or adequate remedy? If it did, then it has provided the protection of the law. And that is all that has to be shown. My Lords, I now, if I can elaborate on my four main points. The first is this: the Court of Appeal of my submission was plainly correct to hold, as it did, that the way the judge decided the case was not the way it had been put. And if I can just take you briefly to the judge's judgment and to the Court of Appeal's judgment. And the first is in page 126, paragraph 126, paragraph 44.
Sorry, paragraph
44.
Thank you.
And 44, 126, the judge holds what this court must do in the instant case, therefore, is to consider in broad terms whether the claimant has been treated, quote, fairly by the state in the circumstances. What can be considered to be unfair depends largely on the circumstances of the case at hand, so a court must consider the facts before it and consider carefully whether in those circumstances there has been a sequence of events which are so egregious that it would be unconscionable for a court to countenance the claimant's suffering as a result of it. In the instant case, what transpired was that the then Chief Magistrate was sworn in as a judge while she had 53 part-heard matters that were left without being properly determined. Well, obviously there's no objection to that. In the case of the claimant, this matter was an advanced stage. The reason for this state of affairs is the subject of other pending judicial proceedings, and therefore I'm careful not to cast blame at the foot of any person as to why the then Chief Magistrate was allowed to demit office as a magistrate, to take up office as a judge without first putting things in place to deal with part-heard matters. My Lord, so far so good. There can't be any criticism of that. And indeed, he is rightly saying that I can't possibly decide exactly what happened. It's not before me. I'm not going to cast blame on that. The difficulty is in paragraph 47, he effectively goes straight back on that. However, what I do find disturbing is that whatever was said or not said by the then Chief Magistrate, there was nothing done by the JLSC to ascertain what was the status of the matters before the Chief Magistrate, and measures put in place to ensure that no part-heard matter would have been negatively affected by the Chief Magistrate's demission from office and elevation to the High Court. Nothing to prevent the swearing in of the Chief Magistrate being put off until part-heard matters were completed. And then he continues, I find that this was a duty that the JLSC had and has when persons are appointed to judge of the High Court from positions of judicial office within the ambit of the JLSC, masters and so forth. My Lord, there was absolutely no evidence, no argument, no pleading on any of that whatsoever. And that plainly is a finding that couldn't stand. And it's important because the judge then goes on to say in the following paragraph, therefore, in the very narrow circumstances of this case. So he is basing his judgment on actually a finding which wasn't open to him.
Which is the finding, the last sentence, is that the one you're focusing on?
Yes. Well, indeed, all of 47.
But surely, the last sentence is I may have anticipated what you were going to say, is a conclusion of the law, isn't it?
That is a conclusion.
A certain duty was owed in a certain factual situation, namely the promotion of a serving judicial officer to another incompatible position.
It's the facts he finds in 47 which are more important. That's just not before them. In other words, quite what went wrong wasn't before them. We know something went wrong. Was it the JLSC's fault? Was it the Chief Magistrate's fault? We don't know. That's the first point I make. Those facts weren't before it. And the state had no opportunity to say anything about it. But even on the second point, my lords, I accept your point, well, that may be pretty uncontroversial in real life. Nonetheless, you've got to put that type of point to the state before you make a finding on it. might be said duty owed to whom, and so forth. But, my lords, I do submit this finding, that 47 as a whole, the facts, perhaps more importantly than the legal point, simply weren't in evidence at all.
But the first sentence, leave aside
Yes.
the reference to JLSC and substitute the state.
Yes.
Is there really any controversy about that?
Well, my lords, it's difficult. I happen to know about that other case, but all I can say is, my lord, that it wasn't totally straightforward. It is the subject of other litigation. Yeah. It's not as, and I think you were taken to some of the extracts in the judgment of Madam Justice Goban, which describes some of the history of this matter. It's not necessarily a case simply that the JLSC not having sought to ascertain what the state of the lists was, and indeed what types of cases were still outstanding. Because there's one thing, my lords, to have a part-heard case outstanding where there's oral evidence. It's quite a different thing to have cases where there's been no oral evidence at all, and which has been adduced before magistrate. So, my lords, I do submit this was exactly the type of finding which it wasn't open to the judge to make. It doesn't follow, of course, that other findings couldn't be made. I accept that.
What about the second sentence of paragraph 48? Why couldn't the judge make that finding?
Well, the second sentence, up to the word state, my lord, I accept if he had said, I do not know precisely what went wrong, but something did go wrong, and that was either the fault of the Chief Magistrate, who had heard the appellant's case, or it was the fault of the JLSC, I do not know, then I accept, my lords, then that I'd be in difficulty challenging. I mean, I accept, if I can put it this way in broad terms, something went wrong here. That's obvious. But simply to cast the blame on the JLSC, as the judge did, I submit, was wrong. And that did require the Court of Appeal's intervention. And that's the only point I'm on at the moment.
You're just focusing on the JLSC's.
Yes, yes, yes.
They're just an arm of the state, aren't they?
Well, they are.
I mean, supposing actually it was the fault of another arm of the state,
Yes.
Does it really make a difference?
It does, because you have to be told, as the state, that what exactly the fault alleged is. So the state can then say, in a protection of the law claim, well, this is what happened. It was maladministration, but it wasn't arbitrary. It wasn't irrational. It's perhaps understandable. But it is important that if the state is being accused of having done something wrong, you say not only did you get it wrong, we know something went wrong, but you at least make some attempt to identify what it was.
But this was a claim being made by somebody who was in prison, who might be supposed not to know awfully much about what went on behind the scenes concerning the promotion of the Chief Magistrate. What did the state do to help the court to understand what had happened, or to suggest that blame might be apportioned otherwise than it was than was being suggested?
Well, I'm going to come to that. The problem is the way the case was put. I'm going to come to the way the case was put. But the case was not put against the state on the basis that the case was simply put on the basis you must pay the $150,000 because I've been subjected to a second preliminary inquiry without justification. That's what it comes down to. There was no specific inquiry invited, by the way the case was put, into precisely what had gone wrong. That in one sense is the problem.
It was plainly being said that the need for a second inquiry was the result of some form of maladministration by the state.
That certainly is the case.
If what you're saying is, well, we don't know whether it was the JLSC or some other emanation of the state or even the judge, well, that was all a matter for the state to raise, wasn't it?
My lords, in my submission, it depends on how the case is being put. If the state accepts that there is some maladministration, but the focus is not on the nature of that maladministration, then so be it. If the focus of a case against the state is not, you breached my right to protection of the law because of these particular events, but the focus is simply, you breached my right to protection of law because you refused to pay my new lawyer, or you refused to pay $150,000 for the second preliminary inquiry. In my submission, the state is entitled to say, well, that's your claim against me. You're not inviting any particular focus on what went wrong in this sequence of events, and therefore the state is not, in my submission, in those circumstances, obliged to put in any evidence. If the case had been put differently, I can see the point. But I would...
He relied on the so-called colossal misstep.
Yes.
And exhibited to go with judgment.
Not on this point, my lord, exactly that. But anyway...
You cited from it.
Yes,
Colossal
yes.
misstep is part of the...
Yes, in the fixed date claim form, he recites, the appellant does recite, I accept this, from that passage where Madam Justice Govan, I think, talks about a travesty of justice. I accept.
And that was a finding that had been made in legal proceedings between the appellant and the state, which weren't the subject of any appeal.
Yes.
I mean, was not the appellant entitled to treat those findings as, if you like, a given when it got to a constitutional claim?
Well, my lord, it may be. My lord, it may be I'm on a narrow point, because I have accepted that what is wrong with 47 is it attributes a particular type of blame. And I do submit it is important that when one is considering whether someone's been deprived of the protection of the law, one doesn't overstate what the case is, or at least one recognises that there may be incompetence here, or mix-up, or whatever, which has resulted in the need for a second preliminary inquiry. That's one thing. But for a judge to make a finding that there was a particular error made by the JLSC, I submit was wrong. And, my lord, the only point I'm on at the moment is this. This error by the Court of Appeal was, error by the judge, the Court of Appeal was entitled to say, well, that was wrong, and the Court of Appeal at that point was entitled then to review the case. I'm not at the moment on the question of what the Court of Appeal should have done. I'm simply on the question, was this a finding which justified the court's intervention? It doesn't, and I accept this, it doesn't lead to the consequence of itself that the appeal had to be allowed. I fully accept that. That's why I want to come to my second point. But my first point is simply, was the Court of Appeal entitled to intervene? In my submission, yes, it was. It doesn't follow from that it therefore should allow the appeal. That's a different point. And, my lords, I only say that because in paragraph 48, the judge says, in the very narrow circumstance, therefore in the very narrow circumstance of this case, he appears to be pinning it on a particular proposition. We say that particular proposition was wrong. Query, there may be other propositions which he could have accepted, and which might have entitled him to come to the same conclusion. I'll come to that in a moment, if I may. My lords, it is important that I'll come to the pleadings in a moment, but it is important that this simply wasn't where it was put at all. And, my lords, I think that's common ground. And therefore I submit the Court of Appeal was perfectly entitled to hold, as it did when it said the judge wasn't entitled to make that finding. Now, as I understand, the real point in this case is, does it matter? So what? The judge got it slightly wrong. He pinned the blame on the JLSC, but the fact is an arm of the state somewhere went wrong. And this should never have happened. And, my lords, I'm bound to accept this just shouldn't have happened. But we say that doesn't get the appellant home. Because the appellant's case was not put on the basis, and this is important, that the JLSC's error of itself was a breach of his right to protection of the law, such as to entitle him to reasonable compensation for the consequences. That was not how his case was put. He put his case much higher. His case was the very refusal to pay the $150,000 in legal fees against this background was a breach, both A, of his rights to a lawyer of his choice under Section 5, and B, correlatively, his right to protection of the law under Section 4B. Regardless, and this is the point I wish to make, regardless of whether, in fact, he was in the event put to any extra expense or imprisonment. That's how he put his case. I'm entitled to $150,000 flat and vindicatory damages. That, in my submission, was overstating the case, and that is, in the end, what has caused the problems, which I mentioned earlier.
But within what you describe as that overstatement,
yes,
isn't there by necessary implication the assertion that the very fact that he had to get a lawyer for PI2 was the result of something done wrong by the state which affected his protection under the law. Because nobody could just go along and say, well, whenever there's a second, and indeed they didn't, whenever there's a second preliminary investigation, the state ought to pay the defendant's costs. They said they're not saying that.
No,
they're saying there only is if something, if the reason why there has to be a second investigation is because of some piece of, whatever you want to call it, maladministration by the state.
Yes, but well, my lords, you've got my point, which I made in opening. The difficulty is because of the overstatement, there is simply no evidence adduced by either side as to what you might call the causation points. If this case had been put on the basis, the state breached, on the face of it, breached my rights to protection of the law because of the elevation of the Chief Magistrate to the High Court bench, with the result that there had to be a new hearing. I therefore want compensation to the extent that I'm put to extra expense, to the extent I'm put to extra expense, and to the extent that I am forced to stay in prison longer. My lords, I can see that it might be that I would be in difficulty. It all depends upon what happened in the event. But if you posit, let's say, that allegation, and if you posit also that as a result the appellant stayed in prison for another 6 years, I've been in very great difficulties. That, one would easily say, is a breach of the protection of the law and on a claim that was properly put. The trouble is here, we know that the second preliminary inquiry was concluded very quickly, and we don't have satisfactory evidence as to the extra expense that was incurred by reason of the second preliminary inquiry, and we don't have satisfactory evidence as to the extent, if any, to which the need for a second inquiry prolonged the imprisonment. That is the difficulty.
And were any of those points made to the judge?
Well, no, because this wasn't the way the case was put to the judge. The case that was put to the judge is, I'm entitled to $150,000. I'm going to have to take you to this. My lords, I know you might say it's all being very narrow, this, but I submit the state is entitled to meet the case that's put. And if you put, as I submit, the wrong case, and you overstate your case, and then you effectively lose, in this case, in the Court of Appeal, it's difficult then to come back and say later, well, I could have put my case rather differently, and some of the bricks for it are there, but when other bricks aren't there for that case. And that's essentially my position.
But the first instance judge clearly didn't see the case as narrowly envisaged as you're suggesting. Why are we to regard him as plainly wrong to have taken the view that actually, as I was trying to indicate before, there seems to me a sort of direct claim and there seems to be an indirect claim. I mean, they're claiming damages, he's taking notice of conditions in prison and things like that. That would have been irrelevant on the direct claim. So he does seem himself to be taking the view that it was wider.
I agree with him. I agree he does that. And that's my complaint. Yeah. That is the issue in the case. I can well see, my lord, that if you were to look at the fixed date claim form, the affidavits and so forth, and the written submissions and say, it's pretty plain that there was both the direct way of putting it and the indirect way of putting it, and the evidence supported the indirect way as well, then I would accept the judge would have been entitled, subject to alteration in precisely how he puts it, to come to his conclusion. But that wasn't how the case was put. And therefore these questions didn't arise before the judge, and what he did was effectively, he made the case for the appellant, which they themselves hadn't made.
Now that point you have made.
Good, my lord,
Is it time to look at the pleadings?
Yes, I wanted to do that, yes.
And am I right, Mr. Knox, in saying that there was no oral hearing before?
That's right.
Yeah, it was all decided on the papers.
All on the papers, yes. My lord, one important preliminary point to remember is that the appellant was relying on the same facts for the breach of the Section 5 and the Section 4 duty. He wasn't saying, for instance, there was a breach of Section 5 by reason of the refusal itself to pay for my lawyer, but alternatively, if I'm wrong on that, there was a breach of Section 4B because the state acted arbitrarily in elevating the Chief Magistrate and so forth before she'd finished her case, with the consequence I should be compensated for my losses. And my lords, one can pick it up in the first bundle at page 6. This is a certificate of urgency. It begins at page 4. Page 6, paragraph 5.
I'm so sorry, page...
6. You have that?
What of the main bundle?
Of volume 1.
I'm afraid I'm using the electronic pagination as we have been until now.
Yeah, it is electronic.
My page 6 is
Certificate of urgency.
It's a claim.
oh, I'm so sorry. Yes, I'm just looking at one bit of it. Yes, forgive me. Yeah. Page 6, yes.
Paragraph 5, the appellant recites the effect of Madam Justice Goodman's decision. As a result, the claim, I haven't been able to retain counsel to my choice. Then paragraph 6, second PI occasion as a result of a colossal misstep, and so forth. And then over the page, 7 and 8, claimant's not responsible for the travesty of justice. It would be unfair and oppressive if the defendant was effectively denied his constitutional right to access counsel of his choice. As a result of debacle he has no control over. The claimant he's already paid a significant sum for the first hearing. The refusal to pay the claimant's legal fees occasioned by fresh PI is unfair and oppressive, can't reasonably be justified, and so forth. So the way what he's saying there is that in terms, I've got to pay my legal fees, and the state should cover those legal fees, those private legal fees. And then you have the fixed date claim form, page 10, begins at page 9. Again, you see the way it's being put. The claim is for, begins page 9, and then you turn to page 10, or get to page 10, is in respect of the violation of his constitutional rights as a consequence of the state's failure and or refusal to pay for the counsel of his choice to represent him in the preliminary inquiry, occasioned by the failure or conduct of the judicial arm of the state. But what the breach of constitutional rights that's being claimed is non-payment of the fees. He's saying, essentially, well, the state made a mess of things in the past, therefore my constitutional right is that they pay my fees. He's not actually saying the previous colossal misstep was of itself a breach of his rights. And you see the claim, the relief that's claimed, B and C in particular, an order directing the claimant to pay the legal costs of an occasion. But he doesn't fix them at any particular amount at this point. And then paragraph you then turn to page 24, I think, which is the section headed Grounds for Relief. And he recites section 4 in 36 and 37. And then 38, the right to counsel. He sets out what the rights to counsel are under section 5. And paragraph 39, the claimant's entitled to protection afforded by his constitutional right to be protected and properly represented through full and proper access to counsel, and so forth. And then paragraph 40, he recites, in 40 and 41 and 43, he recites extracts from 3 cases, which are all to do, essentially, with your right of access to counsel as such. This is in support of the argument, obviously, that the state should pay for the legal expenses of Mr. Sturge. Full stop. And then paragraph 43, I do want to take to this, and my learned friend took you to it, but I do want to take to this to say what I say is the proper view of it. In paragraph 31 of Her Ladyship's judgment in the JR proceedings, Goban J held that some justice may be provided by those responsible for being held to account. The claimant is not responsible for the travesty of justice occasioned by the resignation of the former Chief Magistrate, and therefore cannot be held responsible for the consequential financial effects on himself and other litigants who had their PI's part heard, which is now to be heard de novo. Unfair and oppressive if the claimant, as a result of the actions of the defendant, was effectively denied his constitutional right to access to counsel of his choice. As a result of the debacle he has no control over, he's paid a significant sum to ensure he has counsel of his choice for his first PI. The claimant is now being denied of this right as a result of in the judgment of Goban J, failure of the state. The refusal to pay the claimant's legal fees, occasioned by fresh PI is unfair and oppressive and breaches the fundamental principle of justice and rule of law. Cannot be reasonably justifiable. Now, in my submission, just one looks at that, the constitutional breach that's being alleged is the refusal to pay the fees. It's not actually being alleged that the promotion of the former chief magistrate of itself amounted to a breach of the protection of the law. Now,
Well, that's described as a travesty of justice.
it is.
Which, if you like, was the immediate cause of
Yes.
his inability to fund counsel of his choice.
It is. I accept that. But I do submit that the substance of this is my constitutional claim is for a claim that you must pay my fees come what may.
Can we just go back to page
Yes.
23?
Yes.
Here,
Do you say 23?
23, page 23, paragraph 33. It is said that the incarceration has been extended by mismanagement of the judicial appointment system, and the claim has been placed in this position by a colossal misstep. So it's not just about fees, that.
No, my lord. I think, my lord, in fact, here, what in paragraph 33, as I read it, one has to start at paragraph 29 on the previous page. He's talking generally about the fact he's already been in prison a long time.
Yeah.
Well,
Extended?
Well, yeah, in paragraph 29, he's talking about the original preliminary inquiry.
Yes.
He's been in prison since 2010, and that continues in 30 and 31, 32.
Shred of hope the claimant had was of knowing that his first PI was almost completed.
Yes, sorry, my lord, which
Paragraph 29.
yes. But I accept that is what it is saying here, but he's not. It does also, it's gone on for a grueling 5 years, prior to which he was remanded, but he's talking there about the former PI. And, my lord, he continues essentially saying,
Paragraph 30 then
yes.
is the consequence of the second PI.
Well, he says, indeed, this is what is anticipated. My lord, I would accept that what's anticipated, he will now have to join the queue with other interested parties as well as new cases. No indication of how long it will take. What he doesn't say is that he has already, he's obviously saying, I expect that it's going to take an awfully long time. The problem with this is it doesn't deal with the point that, in fact, the second PI was dealt with very quickly. But that he couldn't have dealt with that at that point, because this is dated, I think, April 2009, or maybe March 2009, and the second PI hadn't yet begun. So when he makes his initial claim, he obviously doesn't know that actually the second PI is going to be dealt with very quickly. But he doesn't, as I read him, say here, well, I have already, the second preliminary inquiry, the order for a second preliminary inquiry, has of itself necessarily extended my time in prison.
Well, I think he says that in 33, doesn't he?
Well, that would be the last sentence.
Yes.
My lord, I think I'm bound to accept, has been extended, but he can only be talking about that.
And then he then says in 34, that's as a result of the colossal misstep.
Yes. And then he goes on to say, I want
Yes, he then says he wants his accordingly, I should have my
legal
costs for the second
Yes.
PI.
Yes. But the thrust of this, in my submission, is directed towards a claim for the cost of his second PI. He does mention, I accept that, well, I've been in prison for longer at that point. My lord, the difficulty is we don't know. The question of what I call causation about the missing 2 years is not really before the court, but this isn't the way he's not really putting his claim on that basis. That's what I say. And I'll come to the evidence in a moment. My lords, what I submit, the proper construction of this document and the further documents I shall come to, is this. In the circumstances, you must pay for my lawyer, for the second PI. There's no claim, at least clearly put claim, for compensatory damages on the basis that he has so far spent more time in prison, and the claim for vindicatory damages is therefore just for damages by reason of the breach is alleged, that is, the failure to pay. the costs that he's asking for. My Lords, one then turns to the first affidavit, and if you turn to page 331 in the second bundle, paragraph 17, the relevant passage begins at 331:14. He says he was in court when his PI came up for hearing. He says in paragraph 16, I've been in custody for a long time, and then paragraph 17, in the premises I consider it inherently unjust to be remanded for such an extended period of time because of the mishaps and mismanagement of the justice in the justice system. Now, my Lords, the only reason I emphasise that there is, again, he's not actually saying that those mishaps and mismanagement are of themselves the breach of the protection of the law. And one gets the same theme as one goes on, paragraph 18. He deals with what happened up to Madam Justice Gobin's order. That's paragraphs 18 to 27. He goes on to deal with the subsequent history up to Madam Justice Gobin's order. And then, at page 335, and he recites from Madam Justice Gobin's judgment, and then at 335, paragraph 28, near the foot of the page, additional prejudice suffered by the claimant. And he says at paragraph 30, Mr. Wainsterd's requisitioned the sum of $150,000, which has been paid to represent me at the first PI. And, my Lord, I emphasise this, Mr. Serge has indicated that the cost of representing me in the second would be $150,000, and he's the attorney of my choice again. My Lord, you'll note it's not said there that actually there was an agreement that that would be charged come what may. I have confidence in him, and so forth. Paragraph 31, I can't afford to rehire my attorney. He then goes on in paragraph 32 to 33 to complain generally about the prison conditions. And he says in paragraph 33, there's no indication of how long the second PI is going to take. It may even be longer than the first one. And he complains in paragraph 34 and 35 about the prison conditions. And 36. And then the last sentence of 36, he repeats what he'd said in the fixed state claim form. That incarceration has been extended by the mismanagement of the judicial appointment system, the injustice of which has already been noted by Gobin J. Then 37, I've been put in this position by a colossal misstep. It's grossly unfair. Then he goes on 38, 39, more or less along the same lines as the fixed state claim form. Having regard to the novelty and so forth, I'm seeking law the state bear the cost of my legal representation, although I'm presumed innocent, the conditions are degrading. And then he says, I instructed my attorneys to issue a pre-action protocol letter.
It seems that he's influenced to a considerable degree by the outcome of the proceedings before Justice Gobin.
Yes.
As related in paragraph 27.
Yes.
On page 335. That that it was lawful for the Chief Magistrate to restart the PI de novo.
Yes, that's right, my Lord. Yes, he's saying that. All I'm saying at this point is the focus here is simply on what it's all leading up to, if I can put it that way. What this is all leading up to is I'm entitled to be paid the fees that Mr. Serge has indicated to me. There's very little, really, along the lines, and I have already been incarcerated for longer than I would have been had the first preliminary inquiry come to an end. He mentions the point, but at this stage one can understand why, if I may put it that way, because this is all very early days, and he doesn't know the second preliminary inquiry is going to come to an end very quickly. The real problem is the lack of any evidence about these points once it does come to an end very quickly. And that is the point that I'm really seeking to make. And like my Lord, one can look at the way he puts it in the submissions, written submissions. Now, of course, these submissions are made after the second preliminary inquiry has come to an end. And I think Mr. Logan took you to this, but I'll repeat it. It's a page 42, bundle 1, page 42. Paragraph 5, page 42, paragraph 5. The issue is whether an aggrieved citizen is entitled to have the state pay for the retention of his defence counsel for the de novo PI, where the first PI was aborted and nor to be reheard de novo before another magistrate, in circumstances where the rehearing is a direct result of the action and or in brackets, conduct of the state, acting through officer of the judicial arm. Now, my Lord, we say that was indeed the issue that was raised by the pleadings. That's an accurate description. Is it fair that he should be made to pay twice? We say that is a perfectly good description of the real point in the case. And then, likewise, paragraph 44D. This is recitation of the facts. Paragraph D on page 44. It's 8D, page 44. He talks about the appointment of the Chief Magistrate to the High Court bench, and then the result was extensive litigation in the High Court to sort out the administrative quagmire that the judicial arm of the state had found itself in. Clearly there's a complaint about this, but it's not being said that this equals the breach of protection of the law. And then likewise 47, paragraph 9, I think. There's a generalised way of putting it, what the issues are, and then paragraph 11, paragraphs 1331 of her judgment, Madam Justice Goben, her ladyship had the following very damning, we dare say harsh words to say about the travesty, which was inflicted on the claimant due to the state's negligence and or incompetence and or recklessness in causing this state of affairs. So there you do have an allegation, of course, that the state's to blame for all this, but again, it's not being put on the basis that this was of itself the breach of protection of the law. And then there are further examples, but I can take it to page 74, if I may, paragraph 45. The defining and inescapably damning feature of this case is that the claimant did, in fact, have the funds to pay for counsel of his choice for the first PI. It was due to the fault of the state that he now had to fork out a significant sum of money to pay for a lawyer for a second time. This is the crux of the case. That's the point the defendant misses. Now, my lords, it's important to note there's no reliance as such in any of these written submissions, or indeed in any of the affidavits, on the facts which are set out in Madam Justice Goben's judgment about the background to the dispute. That's to say, what happened as between the Chief Magistrate, the Chief Justice, and all the press announcements, which my learned friend took you to this morning, which are set out in Madam Justice Goben's judgment. But in these written submissions, there's no reference to them at all. And indeed, my lord, the reference to Madam Justice Goben's judgment, the way it comes in is simply, so to speak, by a sidewind. If you go, please, to page 338.
He does say in 45 it was due to the fault of the state.
Yes.
That he now had to fork out a significant sum. Now, the fault of the state is a very brief shorthand for all.
Yes.
All that has gone on, which is detailed in the documents which are before the court.
I agree with that. I agree. But, my lord, the way he's putting it is the state was at fault, but he's not saying that fault of itself was a breach of his right to protection of the law. And he's not
Well,
therefore...
isn't he saying it was a combination of the colossal misstep and the fact that he's got to pay a significant sum, as it were, a second time, that constitutes circumstances engaging Article 4.
Well, he's going further than merely saying engaging. He's saying I'm entitled automatically.
Entitling him to relief.
Well, entitling him to $150,000 full stop.
Yes.
And he's not saying, because of this, I'm entitled to be paid the difference between what I would have paid to complete the first, and so on and so forth. He's not saying that.
No, but I think the point I'm trying to make is that he's not putting his case on the basis simply of Article 5b.
Oh, no, certainly not. No. It's Article 5b added. He's basically saying, I'm different from the usual claimant. I accept this. I'm different from the usual claimant because my claim to be paid privately for my private legal fees is occasioned by the fault of the state.
Yes.
I just wanted to just make this point about what part of Madam Justice Gobin's judgment was really before the court, because it's not mentioned in the written submissions, and the only way it came in is if you turn to page 338.
Paragraph 36.
Paragraph 39, my lord, 338. He says in paragraph 39, on 12th of February, this is in his affidavit, first affidavit, I instructed my attorneys to issue a pre-action protocol letter, and so forth. A true copy of the letter is here to annex at AC6. You then go to AC6, and you see it at 653. And this letter recites from Madam Justice, as were the relevant part of Madam Justice Gobin's judgment, which he relies on, about the travesty of justice, in support of his claim that he should be covered for his legal fees. And then he simply attaches to that letter, as an exhibit to the letter, or attachment to the letter, Madam Justice Gobin's judgment, which is where you find all the things my learned friend took you to this morning about the background to the problem, about how it all occurred. And that, in particular, you can see that part of the judgment. I think my learned friend took you to this at page 660 onwards.
But he also refers to it in paragraph 36 on 338 as the underlying cause of the extension of his incarceration.
And paragraph 37.
Yes.
Well, there in my submission, what he's particularly talking about is the conditions in prison, which are also mentioned by Madam Justice Gobin's judgment.
Extended by this management, as has been noted by Madam Justice Gobin.
And then in 37 he goes on to say that that has also led to his increased legal costs.
Yes, I accept that. I'm simply saying that what he is specifically, but what he is not relying on specifically in his written submissions or his written submissions is actually what happened, which my learned friend took you to this morning. He's simply saying there was a colossal misstep. That's what Madam Justice Gobin found, and that has that has prejudiced me. That's what he's saying. I accept that. But he's not saying in terms that all this of itself amount to a breach of protection of the law. He's basically saying this entitles me to have my legal fees. That's the way I submit he's putting the matter. My lords.
What about the actual, just to go back to page 42, the actual claim on the fixed date claim form? The distinction between paragraph B and paragraph C. Paragraph C is clearly the case that you believe alone was being put. Why would you need paragraph B?
Well, my lord, I accept monetary compensation. He's asking for both. I accept that. But he's not laying the ground for saying why it is he's entitled to monetary compensation, save for what he says anyway in relation to C, that is to say, I want $150,000. I want my legal fees paid.
So you say overall, B just gets substituted. Well, sorry, B and C are just driving at the same thing.
They are driving at the same thing. My lord, I've made the point before. The evidence there's no attempt in the evidence to say I have suffered. I've had to pay more than I would have had to pay, even if the first inquiry had continued to its end. There's just no evidence on that. And there's, apart from the occasional references, I am now going to be in prison for longer, and my time in prison has been extended by prison conditions. There is nothing, not surprising at this stage, which goes to the point, well, by how much and what has the consequence been? And the real problem is, after he's let out, as a result of his no case submission, we don't know how much worse off he really was than if the first preliminary inquiry had come to its natural end. We just don't know.
Well, that's an objection you could raise. The point you're on is that you didn't know the case to meet.
Well,
therefore didn't ask those questions or put in any substantive evidence.
Well, you say, I accept, my lord. We knew that he was complaining that there'd been a colossal misstep.
Yes, and that had resulted in his time in prison being extended.
Yes.
And him having to pay additional legal fees.
For which
he comes to a sort of request for further and better particulars now.
Well, my lord, I accept that we took the position you're not entitled to your legal fees under Section 5.2, or privately paid legal fees under Section 5.2. You are entitled to legal aid, and we're happy to give you that. But we don't go, and we don't, as it were, deal with the suggestion that in our evidence, which of course came before, I think I'm right in saying before the preliminary inquiry was heard, we don't deal with the point that, oh well, your preliminary inquiry was very successful and very quick, and therefore you've sustained no loss. We don't put that point forward. I accept that.
I suppose you could have done.
Well, then the question then arises, was it for us, so to speak, to say, well, there's nothing here, or was it for him to say, once his preliminary inquiry has come to a speedy end, to say, well, as it happens, I can confirm I paid the $150,000, as I had to, and for him to adduce some evidence to the effect that the extension, the order for a new PI had actually, in real life, extended the time for which he was going to be in prison. I mean, in one sense, part of the problem is most of the evidence comes at a point when no one knows the result. Once people know the result, no further evidence comes in to say, I really have suffered prejudice. But we say, even on the evidence...
In the meantime, he's put a claim in general terms for increased incarceration and increased legal expense, and he identifies the new brief fee as a albeit a fairly high level of generality, a prima facie measure of the increase in the expense, to none of which, as I understand it, did your side put in any kind of challenge or response at all. You just denied the claim in limine and left it at that.
I think, I'm not sure if I don't think we accepted, but I don't think we took issue necessarily with the size of the brief fee that Mr. Sturge was asking for. Well, it wasn't the brief fee. I just want to make that point. He indicated that it would be $150,000 for the second preliminary inquiry.
The quoted fee.
But that doesn't mean it's all due up front. No. But that's what I expect it will be. It doesn't mean you've now got to pay that to me at all in my submission.
But we seem, Mr. Knox, really to have, if I may put it this way, slid from your point 1, your main point 1, to your main point 4. I mean, we've moved away in the discussion we've just been having and the submissions you've been making, whether you knew the case that was being put against you, to whether, assuming in principle it was a well-founded case, there was the evidence to support it.
Well, if the only case put against me is, and this is my submission, if the real case put against me is, as put by the first issue, I'm entitled to $150,000, just like that, then in my submission I'm entitled to meet it by saying, no, you're not.
What I'm trying to understand is whether you're saying you didn't understand the basis of the claim, the legal basis for the claim, or whether you didn't understand where the $150,000 came from.
I think it's more the latter. Yes. In other words, where you have claimed
the latter came from before. At the stage of these proceedings, that was the fee that Sturgis was quoting. Your point is, well, there isn't the evidence to show that it was, as it were, like a brief fee. You have to pay the whole lot, and there was a lack of evidence.
Yes.
And that really is your fourth main submission.
It is. It comes, in a sense, they all tie up. I mean, we say to show, I'm going to have to come to what is meant by a breach of the protection of the law provision.
Yes, indeed.
But we say you look at the case in the round, and then say, having looked at it in the round, you have to take into account the gravity of the breach and what was it, and you also have to take into account the consequences. Yeah. And it may be that perhaps it's a simpler point, simply to say, even if we did know the case was sufficiently put, once you look at the case in the round, there hasn't been a deprivation of the protection of the law. And perhaps I can deal with that point now, because I think you've got my point about it not properly put. But I would like to put the point that, make this point, it's not very clearly put, as my Lord Burroughs put it, it's, quote, the indirect case. It's brief, the extension of time in prison is briefly mentioned in the fixed date claim form and in the affidavit, but not much is made of it. And then once you get to the end, as it were after the event, there's no further evidence on the point. And so no one quite knows, in fact, what the true causation position is. And that, in turn, goes to the question of has there been a breach of the protection of the law? And my lords, perhaps I can deal with it like that. My lords, I'm just moving forward because I think, my lords, you've got my point about how the case was put. My lords, we say there's been a lot of learning about the protection of the law, but the fundamental test was recently set out by the Privy Council in the CPSAT case, to which you were taken this morning. And I submit there's really no need to look further than that, because it considers the question of what is the protection of the law historically, and goes through the main authorities, and you can take it from that what the position is. What I would like to do, first of all, is take you to page 1237, where CPSAT, I think, begins. It begins actually at 1217, but the relevant passage begins at paragraph 40, well, it begins 1237 at 46. Now, my lords, very briefly, the facts of this case, they may be familiar to your lordships, but in case they're not familiar to all of you, the facts are simply that legislation was passed which required children or young adults to be placed in a certain type of detention centre away from adults. The problem was, when the legislation was passed and brought into effect, there were no such detention centres that had been built. and so as it were, the judges were left with no alternative but to put these young adults or children in prisons. Essentially what the board said, well, there was no breach of the due process provision because the judges did what they could in very difficult circumstances, but they gave a fair hearing. But then they went on to consider the protection of the law provision. And they held for a number of reasons, Privy Council held for a number of reasons, that there was indeed a breach of the protection of the law provision, because essentially what had happened was that the children had been, or young adults, had been put in the wrong place, contrary to what the law required, for periods of 7 or more months and so forth, and that was a serious prejudice, and therefore there was a breach of the protection of the law, not just the serious prejudice, but actually wrongful imprisonment, effectively. But they held there was a breach of the protection of the law, but not of due process. But what is interesting in my submission is how the court said, or how the Privy Council said the court should approach this type of question. And I just want to short-circuit it for the moment. The passage begins at 1237, paragraph 46. It deals with most of the leading cases on the subject, and it then, what I would like to do is take you first to paragraph 62, which is, in my submission, the test. The board considers... Sorry, 1242, my lord.
Thank you.
The board considers that in any case where the court is required to determine whether there's been a breach of the protection of the law, in 4b, it is necessary first to identify and then evaluate all material facts and considerations. Material, in this context, denotes those matters which have a bearing on the question of whether the right protected has been breached. This will in every case be fact-sensitive and a case-specific decision. And then they go on at this point to deal with particular facts of the case, which meant that there had been a breach. But the points I want to particularly draw attention to are, first of all, at paragraph 71. Finally, it is necessary to consider the impact of the executive's conduct on the two children concerned. This had both legal and factual elements. The legal element is that the conduct was an interference with the liberty of the appellants. There's no answer to suggest that deprivation of liberty was inevitable by reason of the Bail Act, as the legislature had prescribed how the deprivation of liberty was to operate. So that's one point I want to bear in mind. You need to consider the impact of the conduct complained of. The second thing is paragraph 73. The board considers that all of these factors assessed in the round amounted on their face to a serious failure, I emphasise the word serious, failure to afford to the appellants the protection of the law to which they're entitled. To determine, however, whether there's been a breach of their appellants' rights under 4B, it's necessary to consider the legal proceedings brought on their behalf, and in particular the question of prompt and efficacious redress. In the case of Sasha, an effective judicial remedy ultimately materialised, insofar as she was transferred from the women's prison to a community residence, but not until some 7 months had elapsed. No redress was provided for that 7-month period of unlawful detention in the adult prison. In the case of Brian, the corresponding period of unlawful detention in an unauthorised facility was considerably longer, though exactly when it ended, and so forth. And then paragraph 74, the board recognises the priority and expedition accorded by the courts of Trinidad and Tobago following the initiation of the joint judicial review and constitutional proceedings. Standing back, however, and viewed through the eyes of two teenagers, the relevant periods were of substantial dimensions. And they go on to explain what they mean by that. And then finally, the last sentence, this did not, that is to say, the ultimate removal to the right place, did not, however, neutralise the absence of a prompt and efficacious judicial remedy or rectify the unlawful character of his detention. Now, the reason I emphasise that is the fundamental question I submit when it comes to considering whether or not there's been a breach of the protection of the law. One has to consider what the system of law was, which it was open to the appellant to take advantage of. And if that system of law did essentially protect him, then, use the word I just used, we saw a moment ago, then there's, whatever wrong is neutralised because the court has provided a remedy. And that, I submit, is the fundamental question, or rather, one of the fundamental questions. Now, what I say, looking at the matter in the round, in this case, is the following, just on the facts. Although something has clearly gone wrong, there's been incompetence, I accept that. One cannot say that the state has acted in an arbitrary way, or in bad faith, or in deliberate disregard of the appellant's rights. The highest one can put it is that there is an administrative error in appointing the Chief Magistrate to the High Court bench while she had outstanding matters to be dealt with. Quite whose fault that was, we don't know, and wasn't actually an issue in this case. And I submit, however, the lack of arbitrariness is important, because it is not just any administrative error that justifies or gives rise to a breach of the protection of the law. And my lords, I'd just like to take you, if I may, to two cases. One is a judgment of the board in a case called Forbes, a judgment of Lord Millett, which you see at page 1575. Now, my lords, what had happened in this case was a magistrate had convicted the appellant and imprisoned him, but without giving reasons. And so a constitutional motion was essentially brought against that. And you'll see at paragraph 13 The appellant, this is page 1577, the appellant has spent 2 periods in custody, one of 19 months as a prisoner on remand, one of 11 months as a convicted prisoner serving a term of imprisonment with hard labour. So quite serious consequences from what had been, what was turned out to be a wrongful conviction. The Privy Council in the previous case had allowed the conviction. And that's what had led to this constitutional motion. There's then a discussion of the various cases as to what amounts to a breach of the protection of the law. But if I can pick it up for the moment, paragraph 14, 13, the last 3 lines of 13. The question, therefore, is whether a person who's served the term of imprisonment before his conviction is quashed on appeal has been deprived of his constitutional right to due process and the protection of the law. This question has been considered by the board on more than one occasion. They then refer to the case of Maharaj, the Attorney General, in which case a barrister was committed for contempt of court and committed to prison for contempt of court in breach of the rules of natural justice. That claim succeeded, but then still in paragraph 14, near the end of the page, but Lord Diplock cautioned against making claims to constitutional redress save in exceptional circumstances. And he said, in the first place, no human right or fundamental freedom recognised by Chapter 1 is contravened by a judgment or order that's wrong and liable to be set aside, I think, but in any event, or a substantive law, even where the error has resulted in a person serving a sentence of imprisonment. The remedy for errors of these kinds is to appeal to a higher court. Where there's no higher court to appeal to, then none can say that there was an error. Fundamental human right is not to a legal system that's infallible, but to one that is fair. It is only errors in procedure that are capable of constituting infringements of the rights protected by Section 1A. That's the due process provision. No mere irregularity in procedure is enough, even though it goes to jurisdiction. It must amount to a failure to observe one of the fundamental rules of natural justice. That cannot be anything other than a rare event. And then further cases are referred to, which, my lords, just for your note, paragraph 15, 16. Perhaps in 16, if I can pick it up halfway through the paragraph. The due process of law guaranteed by this section has 2 elements. First, and obviously, there's the fairness of the trial itself. Second, sorry?
Can I just interrupt?
Yes.
Things have moved on a little, haven't they, since these cases?
No, in my submission, no.
I see.
And one has to be rather careful with that. I don't accept that, as it were, now the test is much broader. All that the authorities say, and I'll come to this,
This is all about due process, isn't it?
Well, this is about due process, but the fundamental point which is being made here is that if the legal system provides for redress, then you cannot say there's been an absence, in this case, of due process. And that's why I say in the second part of 16, the board's judgment says it's only if it can be shown that the mechanisms themselves, as distinct from the way in which in the individual case they're put into practice, are being or will be subverted, that the complaint moves in the ordinary process of appeal to the realm of constitutional law. And then finally, paragraph 18, picking up on those judgments, Lord Millett concludes, as you can see, second line of paragraph 18, the following citations establish that it's only in rare cases where there's been a fundamental subversion of the rule of law that resort to constitutional redress is likely to be appropriate. However the exceptional case is formulated, it is clear that the constitutional rights to due process and protection of the law do not guarantee that the judicial process will be free from error. I just wanted to emphasise that because certainly this line of authority suggests that mere maladministration is not enough. I accept in a slightly different context, but it's got to be something really rather serious.
Otherwise, you'd find yourself in court all the time.
Yeah, every developer deprives of planning permission on a wrongful basis. But of course, there's a serious point behind all this, because if you expand the amount of claims which can be brought under protection of the law, actually that amounts to a huge, or potentially huge increase in the burden on the taxpayer. So it's a serious point, this. The state will have to pick up for all this.
This, however, isn't a case where there was any appellate way out of the predicament. In the sense that not because the judicial review application determined by Madam Justice Govind wasn't appealed, but simply because if you have to have a second preliminary investigation due to a piece of maladministration, it's inherently not capable of being appealed.
Well, my point about that is that if you leave on one side what I call the 2-year point, if, let's say, the second preliminary inquiry had taken place straight away and there hadn't been that challenge to the de novo order, the second inquiry would have finished exactly the same time as the first. And the point is this: the system of law that was afforded to the appellant allowed him to do that. That's the point.
Subject to cost and time and distress.
I agree.
Yeah.
But on the other hand, he took an alternative route. Now, it may be reasonable or not reasonable to take the alternative route. That is understandable. Maybe he took the alternative route. But if you're looking at the system of law in place, as at the 1st of June 2017, in my submission, the answer is it was plainly open to him to go for a quick and speedy second preliminary inquiry, just as happened in 2019.
Yes, so that would meet the claim for damages relating to imprisonment and so on, but it wouldn't meet the claim for additional legal costs.
If I agree with that, if there were actual extra legal costs, and that's why I submit there's a degree of artificiality in this, because the second preliminary inquiry, as far as I can make out, simply finished off the work of the first.
But this was a point available to the state to take at first instance.
Well, you have my point, my submissions about how the case was put.
Yes.
Maybe it was.
Well,
but even so, my lord, one then still has to consider the judge's reasoning and what the state of the evidence was,
yes,
as to whether he was justified in saying that an extra $150,000 in fact had to be and was spent. But I just want to focus on this because it's the system of law in place, and these cases make plain that if the system of law is there, then you can't complain about an absence of the protection of the law. And my lord, I do want to make this point, although my learned friend, indeed, my Lord Briggs said, I think, that the law's moved on. My lord, I, if I may say, respectfully say, well, a bit. One has to be careful about this. I would like to start with the Constitution itself, because sometimes we get sidetracked into all these wonderful authorities, which are sort of have high statements of general principle. But I submit the starting point is the Constitution itself and what's it say, because I submit it is significant what it says. And I think if I can pick it up, first of all, at... Sorry, I've lost the reference up. 1012. Sorry, I'm struggling with my bundles. Yes, the Constitution itself. At 10.12, the rights enshrined, Section 4, it's hereby recognised and declared that in Trinidad there have existed and shall continue to exist, without discrimination and so on, the following human rights and freedoms, namely the right of the individual to life, liberty, and so forth, and the right not to be deprived thereof except by due process of law. So that's one category of right. And then B, importantly, the right of the individual to equality before the law and the protection of the law. And I just want to emphasise the words equality before the law, because I submit what this section is talking about is essentially your right of access to the court. It's basically saying you're entitled to be treated equally when you go to court. And it's also saying you're entitled to be protected by the courts when you've got a complaint to make. In a sense, the premise of Section 4B is that indeed something's gone wrong, but the courts are there to provide an effective and prompt remedy. I accept it's got to be that. It's no use saying the courts can provide a remedy in 10 years' time. That was the point made in CPSAT. Too late, as it were. But it is to do with the legal system that's afforded by the state. Has the legal system, is it sufficient to meet the problem that you complain about? And if it was, then there's no breach. If it wasn't, there is.
But in the case of someone who is remanded in custody pending a trial, then that person's protection of the law requires, doesn't it, a process of investigation and then trial of the claim against him
Yes.
to be undertaken within a not grossly unreasonable time.
Well, my lord, that case isn't before you. I mean, I take at the moment, the case is not before you on the basis that I was in remand for 6 or 7 years.
No, I'm not. That's why I say not grossly unreasonable. Whether or not 5 years is too long in the first place isn't before us.
Yes.
What is before us is that it shouldn't be extended and made more expensive by a piece of, putting it at its lowest, careless maladministration.
The question would then be, should it not be extended? To what extent? And in one sense, you get into this question of degree. And supposing it's extended, let's say there is some maladministration. Let's say it extends, let's say just on the time point, it extends your time in prison for a month, let's say. Let's say you could prove that somehow. Does that give rise to a claim for breach of the protection of the law when you are able to get to the courts, or some remedy is provided which keeps the delay down to a minimum? Now, my lord, my learned friend would say, well, even if it's a month, there's a breach of the protection of the law. I say no. As long as the system provides a prompt and effective remedy, it doesn't have to be a perfect remedy, as long as it can be said that there was a sufficient remedy given what has gone wrong.
And what are you saying specifically is the system in law in place here?
Well, the system in law is two things. First of all, it's clear from the judge's judgment that if you have to come back for a second hearing, it's expedited. You are
the policy of expedition.
It's the policy of it, and you're put to the front of the queue. Secondly, here, we say, ignore for the moment the 2-year period. There's no doubt the second preliminary inquiry took place within two months or so. There's no doubt whatsoever that was as quick as it would ever have been completed in the first. There's no suggestion that there was any extra delay, in fact, caused by there having to be a second preliminary inquiry of itself. The extra delay arose because of that 2-year gap. And that's why I say that then you get to the question, well, what was the cause of that 2-year gap? Now, one way of looking at it is the appellant's way of saying, well, none of this would have happened but for breach. Our way of looking at it is to say, well, the system of law did provide you with the alternative of just succumbing straight away to a second preliminary inquiry. That's something that could have happened, and had you chosen that course, none of this would have happened.
I wonder how effective that was, though, bearing in mind the evidence that we've seen that was unchallenged, to the effect that he was placed in a position of extraordinary uncertainty and suffered distress because he anticipated at least the risk of being faced with years more in prison as this new inquiry.
Well, that's what, yes, but that's what he says. But on the other hand, we don't know the whole of it, because we do know, on the other hand, the system of law that was provided for him was that he could do that. I mean, I accept your lordship's. It very much depends on, well, in one sense, whose side you're looking at it from. He says, I mean, poor him, to which we say, well, yes, but you could have. There was something available for you to take advantage of. But you maybe understandably chose not to. You went for a more ambitious route. No doubt with a view perhaps to some advantage beyond the speeding up of your inquiry. Because the one thing he wasn't trying to do was to speed up the second preliminary inquiry.
But he might say, well, he couldn't secure the legal representation for the second inquiry.
Well, that goes to the cost point.
Well, not entirely. It might go to whether he wanted to get on quickly with the second inquiry without the benefit of legal representation.
Well, my lord, the trouble is he doesn't raise the question of legal representation.
Well, the trouble is also he didn't raise any of this.
Well, no, but my lords, one has to assume, I mean, the first question is, would it have been open to him to ask the second preliminary inquiry to come along earlier? We say yes. And if he had then, but the real problem then is we say if he had, why would Mr. Sturge have asked for any more money to do 2 more hearings in the first preliminary inquiry than to do 2 hearings in the second?
I mean, this is where we clearly get into an area on which there isn't evidence.
There isn't, but on the other hand...
And where there is a finding of the judge that the fee being quoted was not unreasonable.
Well, that may be because, of course, the 2 years have passed, but we don't know whether that was incurred.
But the other point, Mr. Knox, is nobody would have known at the start of the second preliminary inquiry that it would be over so quickly. I mean, we now know it was over very quickly, but if you were asking Mr. Sturge to quote a fee before the second inquiry had occurred, he might well have said, well, if this one's going to take another 5 years, 150,000 is my fee. We don't know on what basis he was engaged, but it must have been a possibility, at the very least, that it would be another long inquiry.
I say you can't draw that inference. There's no if the policy of the court is actually to give you expedition, and we know the second inquiry was expedited, I submit the only proper inference is that would have happened the first time round. That doesn't mean your lordship's point about fees, but we also say if all that was needed was to make a no-case submission at the end of the first preliminary inquiry, which was eventually made at the second, why does one say that Mr. Sturge actually put sensitive claimed would there be any difference what he claimed in the second inquiry for finishing off the first?
On the face of it, if you have a second preliminary inquiry, have you not got to start over again with the evidence? You actually had to call witnesses, haven't you, in a normal course of things?
Well, not if you're making a no-case submission. Which that's obviously what happened. They looked at the transcripts and said, right, there's no evidence here. Because the one thing one can be fair...
prosecution to bring the evidence, isn't it?
Sorry?
It's for the prosecution to bring the evidence to show there's a case to answer.
That's right. But
and if you're starting again on the face of it, you've got to do that orally, haven't you?
Well, unless, of course, you look at the transcript of the previous evidence and say, look, this is the only evidence they had. There's no point as we're having another hearing. Because after all, this evidence is not normally challenged as such. In real life, it's just...
Well, I think it was in this...
You mean on the...
In the first preliminary inquiry, there was cross-examination.
There was some cross-examination, but that's not necessarily quite the same thing as I put it to you. You're completely unreliable. You're just trying to get evidence out. But what in my submission, we can take it as read that what happened at the second preliminary inquiry, because there was a no-case submission, was it was said, look at the evidence, there's just no case. It doesn't add up. And that's precisely why there was no extended second inquiry.
I mean, it seems to me that at the moment that a core issue is who bears responsibility for the fact that none of this was gone into at first instance in this case. We're here drawing inferences and making assumptions and so on the basis of some facts. Yes. You're rightly pointing out that it hasn't been explored in evidence. The issue is, well, who bears responsibility for that?
Well, in my submission, it is the appellant who bears responsibility for that, for the reasons I've given. The basic way he put his case was when he said the issue in the case is X, well, he was pinning, in real life, he was pinning his colours to that mast. And that was said at the time of written submissions. So I submit it is for the appellant at least to adduce sufficient evidence once we know that the preliminary inquiry came to a very speedy end. It was for him to adduce evidence about the increase in legal fees and for him to explain why it was, if he was saying this, that he spent more time in prison because of the second inquiry than he would even under the first, and why the 2-year gap should be attributed, so to speak, to the fault of the state, as opposed to his own decision to challenge the original order. I submit that was for the appellant to do, for him to prove his case. Especially, my lord, if it's not clearly put. I mean, I can understand if he'd put his case and we just didn't put any evidence in, well, that's our lookout. If he doesn't put his case that clearly, then I submit it's rather different. I'm conscious of I've got little time to go, but I would just like to mention on this point, I've gone on to what you might call the consequences point, but I just want to make the point about the importance of there being a grave and serious breach, what you might, as opposed to, that is to say, something along the lines of arbitrary bad faith, as opposed to mere maladministration. I do just want to make comments on 2 cases. The first is the case of Boodhoo, which you can see at page 1457. And this was a case which went to the court, in which, as a property dispute, it went to the Court of Appeal, and one of the judges died before judgment was given. Judgment having taken about 14 or 15 months or so, and so the appellant said to the state, would you mind coughing up for my legal fees for the renewed hearing? It's all the state's fault. And in one sense, you might think, well, that's entirely a fair thing to say. But the Privy Council said no. And can I just take you? It begins at 1457, I think. there's a particular passage I'd like to take you to. One I've got. Let's check my note, yes. There's a discussion about whether it's Section 4, this was really a Section 4A or 4B case, but the Privy Council said, no, it's a Section 4B case, all right. But paragraph 11, the Court of Appeal held that in principle an excessive delay in giving judgment could infringe the 4B rights. De la Bastide, CJ, went on to say, for there to be an infringement of this right, the delay in delivering judgment must, in my view, be of such an order as would really make a mockery of a person's right to have a determination of a matter by a competent court or tribunal. And then he goes on to discuss, the Privy Council goes on to discuss other cases, English cases, where it had been held that 12 months was too much. And de la Bastide, CJ, goes on to say, well, I don't think it follows that more than 6 months, if the judge takes too long with his judgment and then he dies, that there's necessarily been a deprivation of the right to protection of the law. And he continues at page 1463, top of the page, I think it's necessary to set the bar a good deal higher, that's said in 6 months, before that stage is reached, bearing in mind that our Constitution does not provide any right to trial within a reasonable time in civil or criminal cases. I've already suggested that it's only when the delay becomes so gross as to make a mockery of the party's right to the court's adjudication that the infringement is established. When that occurs, I think better left to be established on a case-by-case basis. And then their lordships are in basic agreement with these views and with the approach which the Court of Appeal adopted. So in other words, it's a high test. It's not just a sort of a maladministration test. It's got to be something like that. It's more along the lines of Lord Millett talking about the subversion of the rules of justice. It's a high test. But the lordships then say to me, but what about the new developments in the law? Can I just ask you to take up page 1954, which is perhaps the high point of these developments, which is the Caribbean Court of Justice's decision in the Mayor Leader's case, paragraph 1954. Sorry, page 1954. And this is in a case I just want to come to in a moment anyway, Sam Maharaj. And this is a passage you'll have seen recited in our cases. But what I want to emphasize here is that it's wrong to say that it is expanding what has been said before. It's actually put in much more general terms. Perhaps I can just take it from the word however, about 10 lines down to the citation.
Paragraph
26.
26, thank you.
However, the concept goes beyond such questions of access and includes the right of the citizen to be afforded, quote, adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. The right to protection of the law, and I emphasize the word may, in appropriate cases, require the relevant organs of the state to take positive action in order to secure and ensure the enjoyment of basic constitutional rights. In appropriate cases, the action or failure of the state may result in a breach of the right to protection of the law, where the citizens have been denied rights of access and the procedural fairness demanded by natural justice, or where his rights have been otherwise frustrated because of government action or omission. There may be ample grounds. So, my lords, that is carefully hedged. And I submit rightly so. It very much depends. One lands up going back to the test which I mentioned in CPSAD. You look at the matter in the round. But I do submit it's not enough just to say I've suffered a serious consequence as a result of this maladministration. That's obviously, I submit, obviously not enough. And then in Maharaj itself, at 1946, the case I've just been looking at, sorry, I have to go back to it, there was a breach of natural justice involved because the industrial court judge hadn't been reappointed to his position. That was basically what happened. And you can see the way the Privy Council put it at 1958 in paragraphs 37 and 38. The argument in this case was whether a breach of natural justice of itself can amount to a breach of the protection of the law. That was what was being said by the state. They said no, it doesn't. And then the board's judgment, I think it was Lord Kerr, paragraphs 37 and 38 and 39. But can I just, I'm conscious of time, can I just ask you to read those to yourself? And I'll just make a comment on it. In other words, there has to be a prompt and efficacious remedy. That's the question. Then, but in this particular case, you could see that there wasn't a prompt and efficacious remedy. In my submission on the facts of this case, there was. The appellant chose not to take advantage of it. Well, that's not a breach of the protection of the law. My lords, I'm conscious of the time. I think I've already gone a minute over. As far as what we say on damages is concerned...
Just before you leave that point, Mr. Knox, in your case, page 983, paragraph 14,
yes,
you set out what you say is required to be shown. Does that summarise your case, or is there something more?
Sorry, my lord.
Paragraph 14, page 983.
Yes.
Last sentence.
Well, forgive me, I've piled up all my... need to say, so I can't read them. Sorry, paragraph 14.
Yes.
Yes. We say 14 exactly, and last sentence, yes. That we say is the essential test. And my lords, I accept that this case is not necessarily an easy one. I fully accept that, because you are, as it were, close to the edge of, well, if we allow this one through, virtually every case could be said, with a serious consequence, could be said to give rise to a breach of the protection of the law. That's why I emphasise the points about, first, the need for serious breach, and secondly, in fact, was the system here sufficient? Now, as far as damages are concerned...
I'm conscious that
I'm going to shut up in a moment.
You're overstepping your time.
I'm not going to make any submission on damages.
He was very precise in finishing on time himself.
My lords, I just want to say on the damages point, we set it out in our
have your written
case.
submissions on that.
But we do invite you to look carefully at what the evidence was. We say, in a word, there's no evidence that Mr. Sturge actually said that it was agreed that he would have 150,000 in the circumstances that happened. There is no evidence of an agreement. And we don't know what actually he did charge over and above what he would have charged. And that's the fundamental point. As far as the vindicatory damages are concerned, I've already made my points.
Thank you. Mr. Ramlogan.
My Lord, there appears to be some misconception about the appellant's pursuit of legal remedies. And at the time this claim was filed, we were actually conscious of the fact that he was incarcerated for a long period of time, and Mr. Charles's instructions were, look, I want to get out. I want to have my PI completed. So what we did is we filed a claim for judicial review to challenge the order for a de novo hearing. At that time, no one said it's going to be expedited. He's in a state of utter uncertainty. There's this banter between the DPP in open court and the magistrate, and things are left hanging. That's the state of affairs. And what he does is challenges the de novo order, because to him, from where he sits in the prisoner's dock in the cage, he is thinking that, look, I'm going to have to wait for a prolonged period. So he challenges that. Now, why does he do that? He does that because there's a Court of Appeal judgment in Trinidad, based on a Court of Appeal judgment from the UK, ex parte Bottomley, which I'll show you is referenced, which suggested that another magistrate can simply receive the baton and carry on and complete it. So, as well as there were other options which were raised and being bandied about by the Law Association and so on. Those were creative options, including the magistrate coming back and completing the parties and then taking up a judicial appointment. So that was the state of play. Now, look, can I start by taking you back to her ladyship's judgment, because it's important that we get some parameters clear. To page 665. At 665, these were the questions at paragraph 15, and I wish to correct my learned friend, it's not the DPP's application, it was the state, through the Attorney General, that made this interpretation application, not the DPP. And you'll see that from the heading at 658, and I think I read where the judge had complimented the Attorney General for making the application. But at page 665, the judge, these were the questions posed to the High Court by the Attorney General, and the parties were the DPP, the presiding magistrate who took over the matters, the Law Association, the Criminal Bar Association, but the DPP and the very magistrate who had conduct of the matters and the state. And these are the questions at page 665A. The manner in which the matters commenced but not yet completed before the Chief Magistrate are now to be determined and or concluded. In other words, they were seeking guidance as to, well, what on earth do we do? Number two, whether Marcia Ayers Caesar is a magistrate, and if so, whether the pending matters of any of them may be continued before her. Now, that issue arose because the DPP had raised the issue of whether she resigned or not. C, whether the pending matters of any of them are required to or may be restarted de novo before Magistrate Cadell or any other magistrate. D, whether the pending matters of any of them may be continued before her or different magistrate and or with the consent of the parties. Mr. Akili Charles was saying, look, I'm happy to consent. One of the things he was saying in his judicial review is, look, I'll consent, let another magistrate do precisely what my learned friend Mr. Knox was suggesting, which is take all the papers, read them, and let me make an okay submission. But that's not what happened. The state resisted that, and I'll show you. And then at E, whether the provisions of the Indictable Offences Act permit the pending matters to be continued at all or to be completed by another magistrate. In that situation, how on earth could the state suggest, when they themselves did not know the answer to these basic fundamental questions, that we could have opted for, succumbed, to use this word, to a new PI? With these questions unanswered? Well, I take you now to the following page, page 666. The relief we sought in the GR, my little friend has corrected it already. We were not seeking to say that we shouldn't have a trial. Au contraire, we were saying we need to have our day in court, but we want it quickly. And in paragraph 5, the judge, this is what the judge said: both matters were originally listed together. That's our GR and the interpretation claim. But in the course of management, the interpretation application directions were overtaken by those of the GR because we were pressing for the GR. Indeed, final submissions in the GR application were filed in June 2018. Counsel then sought, that's me, counsel then sought to urge that I proceed to rule on that matter, but I refused. The delay is regretted. But even with the best efforts at efficient management of the hearing of the interpretation application, several interlocutory applications arose for determination, etc. The short point is the judgment in the interpretation claim was not delivered until January 4th, 2019. I was pressing the judge to give us a decision on the judicial review claim. At paragraph 6, she says, parties to the GR, and then she says this: parties to the GR were at all material times since the inception aware that it was only sensible to await the determination of the interpretation application. Well, I won't say anything to that, but that certainly wasn't my understanding. At paragraph 8, on page 668, the judge says this: on 26th of June, I made a declaration that the former Chief Magistrate is deemed to have voluntarily resigned from a post upon being appointed a judge. Now, that declaration arose because there was an advertisement. The position of Chief Magistrate was advertised by the JLSC. And when that advertisement came to her ladyship, it was in those circumstances that declaration was made at that stage in the matter. That's what the judge did. Then you will see at paragraph 9, these are all of the options that we said were available to the court so that we wouldn't have to have a second PI. The state could have pursued a legislative option. The former Chief Magistrate could have come back to complete it. She could have had a temporary reappointment. Another magistrate could have read the transcript and continued the PI instead of aborting it. Whether a stay of execution should be granted, the prejudice that would be suffered if the matter started de novo, because there would have been a dress rehearsal in the cross-examination, and witnesses may have been better prepared the second time around, to the prejudice of the defendant. The need for proper representation who will bear the cost, etc., the conditions of incarceration, no bail, etc. Now, my Lord Hamblin asked the pertinent, made a pertinent inquiry. Well, is it the case that they just took the battle with the transcript and ran with it? That's what we wanted. They didn't, and for good reason. The reason is, it's at page 671. It's because the board had decided a case of Wong in 1987, and this is what the board had said. In a criminal trial, whether before a jury or before magistrates, it is a fundamental requirement of justice that those called upon to deliver the verdict must have heard all the evidence. The evaluation of oral evidence depends not only upon what is said, but how it is said. Evidence that may ultimately read well in a transcript may have carried no conviction at all when it was being given. Those charged with returning a verdict in a criminal case have a duty cast upon them to assess and determine the reliability, and that should be veracity, I presume, veracity of witnesses to give oral evidence, and it's upon this assessment their verdict will be, etc. Now, the short point is, as my Lord Hamlin pointed out, there was cross-examination. There was 60 witnesses in that matter. There were over 20 hearings at the first PI. And that is what Mr. Charles and Mr. Sturge would have had within their contemplation. It is a de novo hearing. And it was not a case of taking the transcripts, as my learned friend says, with the greatest of respect, reading them and making a no-case submission. No. Cross-examining, a de novo hearing means it starts from scratch. Cross-examination would have had to have taken place. And then I take you, the judge then decides at paragraph 22, page 674, this is the long-awaited pronouncement. She decides that, look, in general, in the result, the general position is that the parted matters cannot be continued before a different magistrate and must be started de novo. So it started de novo. And then at page 675, she says, well, how does, at 24, paragraph 24, how does this ruling impact on JR proceedings? Much of the claim for judicial review was overtaken by the determination of the preliminary issue of the first claim, the decision on the interpretation claim as the status of the former chief magistrate, etc. At paragraph 26, she says, the ruling on interpretation confirms that save for those matters which were subject to section 23(8), the magistrate has no discretion. It would have helped considerably had the magistrate been able to answer definitively the question posed by the DPP as to whether the chief magistrate had indeed resigned and by what means she had terminated her position, etc. And then I take you to the last paragraph, 35 on 678, to show you why that submission my learned friend is making is untenable. Paragraph 35, this is what the magistrate said. She said, sorry, Justice Gogan, she said...
Sorry, which paragraph are we on?
35, on page 678.
Thank you.
Sorry, Lord. She says, I'm inclined to award the claimant's attorney's costs to be paid by the Attorney General, but only up to the stage of filing the substantive fixed date claim form for judicial review. All further costs could have been avoided, not had the claimant succumbed to a fresh PI, but has been avoided had the claimant agreed to a stay of the proceedings to await the outcome of the interpretation application. So the position of the court and the state was not the imperfect system of criminal justice afforded a remedy, which was to capitulate and succumb and have the fresh de novo PI. That's not the case. We were penalized because they said that we should have simply agreed to a stay to await the outcome of the interpretation claim. That's the position. And given the intensity of the prevailing uncertainty. So Mr. Charles, he didn't just act reasonably. He couldn't have succumbed to the second PI because the possibility of that arose after the interpretation claim was finished for him. I don't know about the others that were completed because you see there's mention of the DPP's powers under section 23(8) and so on. But I can only speak for my client. So that 2-year delay, it is not the appellant's fault. In fact, it is the fault of he couldn't be criticized and faulted for the steps he took to seek legal recourse and redress. But unfortunately, it was neither, to the extent that he got redress, it was neither prompt nor efficacious. Because he had to wait 2 years in prison in those circumstances to get a remedy, and the remedy was, let's go to a fresh PI.
And do we know on what basis the second PI came to a swift conclusion?
My Lord, I did take the opportunity to call and find out. They sat, I'm advised they sat day to day. They sat day to day, and the fact that Mr. Sturge was instructed, who had been relatively high on the learning curve, having done the first PI, they were able to move quickly. So they cleared their schedules, and they had a defense counsel who's very experienced and who was in the first PI, who would have been familiar with the material and was able to assist the court in moving quickly.
So how long was the hearing?
My Lord, I'm afraid I had a brief conversation with Mr. Sturge. I don't know how long it lasted, but I could certainly inquire. I mean, the state would have the actual transcript, but we can make some inquiries on that, my Lord. I'm unable to assist further on that.
Was there oral evidence?
Sorry, my Lord?
Was there oral evidence?
Well, my Lord, I think so, yes, from what I understood from the conversation, yes, because, I mean, it would be rather odd if they didn't have the cross-examination again, because then they'd just be relying on the transcripts. But I mean, as the judgment says, a judicial officer would have to observe the demeanor and the attitude of witnesses in the box whilst they're giving evidence as part of a fair hearing, quite frankly. So that I don't see. I think it would have to have been. My Lords, the judge at page 128 to 129, we say he correctly, in awarding vindicatory damages, at page 128, he says at paragraph 50, with respect to vindicatory damages on the authorities, it is my view this is an appropriate case for such an award for the following reasons. As a result of the matter having to be heard de novo, the claimant was kept incarcerated for a longer period of time than he would have otherwise had been had his matter not been reheard. It is well known, and I take judicial notice of the fact that the conditions in remand yard are very unpleasant, to say the least. At the time this matter was aborted and a fresh hearing ordered, the claimant would have been suffering from the possibility that his matter would have been prolonged for even a further 5 years, given the length of time the first hearing took. While I take judicial notice of the fact that it was disposed of within a year, at the time the order was made, the only benchmark within which the claimant would have had to have worked with was the length of time the first inquiry had taken. And he goes on, and I said that the judge was entitled to take that into account in making his award for vindicatory damages. But if a new lawyer had taken this case to familiarize himself with the papers and start from scratch, other than Mr. Sturge, it would have definitely taken much longer. Now, my lords, the floodgates argument. Now, my lords, the gains on protection of the law since MacLeod and the Attorney General before the board have come on a piecemeal basis in very hard-fought litigation, and it culminated with the Jamaicans for Justice case, where the jurisprudence emerging from the Caribbean Court of Justice was given judicial approval and endorsement. This case turns on its own peculiar facts. There is no need to stray beyond the facts of this case, which are exceptional and arbitrary in the extreme, we say, in the least. To trouble ourselves with a floodgate argument and to revisit those gains based on the older authorities cited by my learned friend. Oswald Alleyne was decided by this board in 2015, and 7 years later, there has not been an opening of the floodgate or an avalanche of cases in Trinidad where every act of maladministration, inefficiency by the state has resulted in a breach of protection of the law. No, au contraire. It is still heavily policed by the judiciary in Trinidad, and it's jealously guarded, so that a constitutional violation really it has to reach a certain threshold that results in substantial prejudice and serious consequences. Now, my Lord, in an old case of Bagwandine, Mohanlal Bagwandine, an Attorney General before this board, the issue which we had to resolve was whether to vindicate one's constitutional right, in that case it was right equality of treatment, you needed to prove mala fides. The board in that case and others subsequently has confirmed that there is no requirement for mala fides in order to vindicate one's constitutional rights. And I say that because we must be careful not to reverse those gains, because when my learned friend says maladministration by itself cannot, in and of itself necessarily, as an absolute rule, ever lead as a matter of law to a breach of the right of protection of the law, I say that won't be right. If you have mala fides, it will aggravate the damages, but that's putting it tantamount to saying you can only get it if you perhaps have mala fides accompanying the maladministration and inefficiency, the inefficiency that will occur. So, my Lord, I say, my Lord Hamblin took us to paragraph 14 of the respondent's case, where my learned friends put it as this. Were it otherwise, every successful claim for judicial review could potentially give rise to a claim in damages for breach of Section 4B of the Constitution. On the contrary, it is submitted that mere fault is not enough. There must be something in the nature of arbitrary conduct which seriously prejudices the citizen in the enjoyment of his or her rights, which is neither remedied nor capable of remedy through access to the courts. Well, I agree up to the last part, which says that which is neither remedied nor capable of remedy through access to the courts. Arguably, one should always, in legal theory, be able to have a remedy if one access goes to court. We did that in this case, but it's a classic case of where trying to access a remedy from the court doesn't give you any justice. Because having filed the claim, they said we should have awaited the outcome of the interpretation claim, which took a further 2 years. So I think the qualification I'll put on it is what the board said in CPSR, and that is to say, which seriously prejudices the citizen in the enjoyment of his or her rights, which is, and the remedy afforded by the law is neither prompt nor efficacious. That is how I will complete that sentence. And I say here, on the facts, it is clear, without any doubt, that the remedies the law afforded us were neither prompt nor efficacious, and the arbitrary state of affairs that confronted Mr. Charles, he acted reasonably and should not be faulted for the steps that he did take to try and obtain.
I didn't quite understand. Were you saying that those words are coming from Sampassad itself, or were you putting those words in?
I'm putting it in, my Lord, but I'm saying yes. Yes, it's also in CPSAD. Yes, the issue. It's also, I think, in Samaraj, but the issue of prompt and efficacious remedy. So you might access the court, yeah, but there are many times the court takes a long time.
So your point about the submission by Mr. Knox in paragraph 14 is it's not good enough to provide a remedy. It's got to be something that's prompt and efficacious.
Yes, and it must meet the justice of the case. I mean, there's no point granting a declaration as a commentary on past events, as a hypothetical or academic exercise. That doesn't deliver any substantial and meaningful justice to a man who is a young man who is suicidal and in prison, awaiting trial in grueling subhuman conditions for almost a decade of his life. Well, unless there are any questions I can assist the board with, those are my submissions. I think I'm within time, with 5 minutes to spare.
No, thank you very much.
That's deeply obliged,
and our gratitude goes out to all counsel and those who have helped them prepare their detailed, helpful and focused submissions. The board will take time to consider each judgment.